Karen McAuliffe is our next speaker, and she is a reader and Birmingham Fellow at the University of Birmingham Law School. She is a renowned scholar in European law and language as it relates to law. She has a deviant background as far as this group is concerned, because she actually has studied both law and linguistics. What an outrage. She was a legal linguist at the Court of Justice for some time, and is a leading scholar in the workings of the Court of Justice of the EU. And there's a great deal of work, I've done a little of it myself, on the dilemmas that the court has with respect to construing laws as they're written by the European Parliament and the like. Well, how do they go about this job? And her work is just, it's fascinating. It's really a combination of linguistics, law, and sociology. So within the court operates in French, but that doesn't mean that every justice appointed to that court is very, very fluent in French, because the members have a right to appoint the justices. So what happens is, over time, the court has developed the habit of writing in boilerplate, which the judge's assistants help them do. So at least they can understand it if it's been written 6 times in other cases, and it's really affected the way the court operates. There's much more sophistication than that. I just gave the cartoon version of it, and it's gotten much better over the years, I imagine, because as the institution of the EU has matured, so have the institutions, at least in that way. But in so many ways, Karen is a major scholar in the area of language and EU law, and I'm very proud to have the chance to introduce you.
Thank you. Right now, I don't really know how to follow that. Thank you. Very much. Ja. Ich möchte zuerst Professor Gerhard bedanken für die Einladung und allen, die so gut heute organisiert haben. For me, as an Irish person, this is the perfect example of the most clockwork and organized German workshop. It's just been a dream to work with the team. So thank you very much. And I'd like to take the opportunity to thank Larry as well, not just for bringing this little group together today, but Larry and I met back when I was just transitioning careers into academia, and we don't have to say how long ago that was, quite long ago, and he has been not only an inspiration but a great mentor to me throughout my career, and I appreciate that. What I want to talk about today is a project that I've been working on. I have a European Research Council project called Law and Language at the European Court of Justice, which has been running since 2013, and it looks at the impact of language and translation on the development of the case law of the Court of Justice. And it's based on the premise that language, culture and other dynamics within the court shape the way that the institution works. The project looks at the process behind the production of the court's multilingual case law. And the project itself is divided into 3 sub-projects which are distinct but related. The first looks at how the court functions as a multilingual, multicultural institution and investigates the limitations of producing a multilingual jurisprudence. The second sub-project looks at the development of what I'm still temporarily calling a de facto precedent in ECJ judgments where in theory none should exist. And the third looks at the role of the Advocate General. Since 2004, Advocate Generals at the court have been required to work in one of the 5 pivot languages of the court rather than in their own mother tongue, which they historically had done. So we're investigating whether or not there have been changes in those opinions and whether there has any substantive implication on the law. And each of those sub-projects feeds into sort of an overarching question, which is to what extent language and translation can have an impact on the case law produced by the Court of Justice, and why should we care? about this. So answering, I think, one of the questions from earlier, sort of, why should we care about any of this at all? The project is inherently interdisciplinary, and the basic premise of all of my work is that research that's focused and grounded in just one field is not particularly helpful. And I claim that to get a kind of a full understanding or a more holistic understanding or rounded perspective of any topic, you should think about interdisciplinarity. And the various research questions that I'm asking, or my team is asking, in the project, in each of these sub-projects, they simply can't be tackled, or at least not in a sort of holistic or a full sense, without interdisciplinary work. And so we use methodologies which range from systematic literature reviews, empirical legal analysis of the case law itself, interviews, observational data, and corpus linguistic analysis of the court's case law, the jurisprudence. And analysing the data and exploring the research questions from all these different perspectives allows us to triangulate our findings. Sorry, I'm going to forget to click through this probably. Triangulate the findings, and I feel it ultimately strengthens the research process, and it makes me feel a lot more confident in claims that I might be making. And so today I'm going to be talking about some of the empirical data, and so some slides will show excerpts from interviews. Where I use quotes here on the slides, it's where they are indicative or representative of the entire sample. They're not just randomly chosen just as I would like. I'd like to obviously talk about the whole LLECJ project, but we all want to make it home at some point tonight. So there's a lot I'm not going to be focusing on today, but what I do want to explore is the notion of what I call linguistic cultural compromises. In the late the late 1990s, early 2000s, there were a number of anthropological studies carried out on the political institutions of the EU, in particular by two French anthropologists, Marc Abeles and Irène Bellier. And they wanted to find out how those institutions dealt with conflicts that derived from the differing political approaches and cultures, and allowed the institutions to ultimately express themselves in a single voice. And in their work, they make the point that process necessarily affects output. And they found that in the context of the European Parliament and Commission, the process involves what they called a cultural compromise, through which EU civil servants are able to work together in a unique hybrid environment of those institutions, and the output, which is necessarily affected by that cultural compromise, relates to what they call a culture of compromise, which is visible in the policies and the documents that come out of the court. So you can see the cultural compromises and the culture of compromise in what is being produced by these institutions. So today I want to look at those notions of cultural compromise specifically from a linguistic point of view within the workings of the Court of Justice. And the next question to sort of ask myself is, why language? Why should I be worried about language at all? Our project uses language as a lens through which to study the court, and why is this? Well, from a very basic point of view, I mean, you have to choose a lens. You can't address the overarching research question from absolutely every angle. So at some point as a researcher, you pick your lens, and language is mine. But law is an overwhelmingly linguistic construct. It's created, it's interpreted, it's applied through language. The relatively recent development of the field, or expansion of the field of law and language, shows that in the global legal arena at least, there's an increasing acknowledgement of this among legal scholars. Language, of course, can't be divorced from culture, and linguistic theory claims that languages constitute cultures. Often the same communicative systems exist across cultures, but the form and content of those systems are not identical because different languages represent reality in different ways. Law could be considered a culture-specific communicative system. Legal concepts and legal language arise from the application of linguistic resources of the legal communicative system to real-life situations. And in that process, certain areas of life are juridified. So in other words, they're described in terms of the words used in the law, and they're turned into legal concepts, and then those legal concepts are usually specific to a particular legal culture. So in my opinion at least, language is an extremely important part and has a significant impact of the development of any legal order. But the question of language is particularly relevant when we look at the Court of Justice of the European Union, because that court produces case law in up to 24 languages. The reality is at the moment it's 23. Irish is coming on board, so they tell us. So the question of language at the ECJ is not just about these abstract issues about language and culture and philosophy of language, but it's also about the very real issue of translation. And the biggest difficulties in legal translation, which Isolde I talked about briefly earlier, generally arise because legal systems conceptualize reality in different ways. Legal translators are not translating words, they're translating terms embedded in specific cultural models. So legal systems reflect principles and values that underlie the organisation of a society, and that's why the translation of legal rules within translation theory is considered not as translation of words or ideas, but as an import of foreign methods of organisation of a society. Legal translation is concerned with the incongruency of legal systems. Elements of one legal system cannot be simply transposed or transplanted into another legal system, and we had that wonderful artistic exploration of that from Werner when we started today with his suitcases. In legal translation, the comparison of legal terms precedes the translation. Legal translators must first compare the meaning of terms in the source and target language legal systems, which that makes them aware of similarities and differences in their use across languages. And the general consensus in translation studies and translation theory scholarship is that legal translation and translation generally is at best an approximation. And a lot of lawyers will acknowledge this, and they acknowledge that equal meaning and exact translations between legal texts are illusions that cannot be achieved in practice. And so the claim is made in legal translation scholarship that the task of the legal translator is to make the foreign legal text accessible for recipients with a different legal background. I find this very problematic when considering the case law produced by the Court of Justice, and I'll hopefully be able to explain why as I go through this talk today. To date, most of the work on legal translation, with some notable exceptions, most notably Susan Sarcevic, focuses on translation of legal texts for information purposes, where the source text is the text that remains the force of law. And the claim that the legal translator is, the task of the legal translator is to make the foreign legal text accessible for recipients with different legal backgrounds only works with regard to texts that do not have force of law in the target language. And that is not true in the case of multilingual supranational law, and EU law in particular. In the context of EU law, the ultimate goal of legal translation is to produce parallel texts that will be interpreted and applied uniformly by the courts. So the ECJ, at the Court of Justice, aims to produce statements of law that will have the same effect throughout EU member states, in every language in which they're published, and through such statements ensure the uniform application of EU law. So you could say that the Court of Justice considers there to be one communicative system within the EU, albeit expressed in 24 different linguistic forms across, currently, 28 different legal cultures. Soon to be 27. Taking language as the lens through which to study how the Court of Justice works, and its case law is therefore, I believe, very relevant and appropriate, but also very important. The texts that make up the case law of the court are hybrid in nature. They reflect various linguistic, cultural compromises at play in their production process. And what I'd like to talk about now, today, is I'd like to explore two specific aspects of those linguistic cultural compromises. First, that by which the court's case law is created, and secondly, that by which the court's case law is filtered out through the wider EU through translation. So looking at that first linguistic cultural compromise, the Court of Justice, I am behind on my slides, the Court of Justice operates using a single internal working language. This is very small, I'll go through it in a minute. French. So the court works in French. And each case that comes before the Court of Justice has a language of procedure, and the various documents in the process come into the court in that language of procedure and in the other language, and they're all translated into French. The judgment is drafted in French, and then it's translated into up to 23 other languages. The version of the judgment in the language of procedure of the case is the only authentic version of the judgment. And this is often a version of the judgment that the judges have not deliberated on. It's not the version that they have drafted, and in many cases they don't understand the language of the authentic version of the judgment that they sign. So, and so this is the sort of the very basic overview of what happens at the court. So the case comes before the court. These purple bits are where the translation happens. And so when I was thinking of looking for the impact of language on translation on the case law of the Court of Justice, the very obvious place to look is at these points of translation, you would imagine. But the impact of language on translation on the court's case law can't just be isolated to those points in the process, because translation in a broad sense is embedded throughout the process. And indeed in the culture of the court itself. If we look at how a judgment is drafted, nobody starts with a blank sheet of paper. So a case comes into the court, it goes through these various steps, and when it comes to drafting the judgment, the referendar, because it is in the vast majority of cases not the actual judge rapporteur who drafts the first version of the judgment, it is his or her legal clerk, legal assistant, known as referendar. They will start with a document that already has the structure in place, and they can't change that. There are many things that are automatically populated. So the subject of the case, the legal questions, the relevant legislation that is being questioned or considered. That is all automatically put into the document. I think somebody talked about Article 260, was it Jan? Did you talk about Article 267 references earlier? References for preliminary ruling? Yeah. So most of the cases that come before the Court of Justice, not the Tribunal, the Court of Justice, are these references for preliminary rulings under Article 267. So they're questions sent by national courts to the Court of Justice. And what often happens is that the court will rephrase the question, or put two questions together, or separate a question out into two questions. So that is done at this point. And then a report is drafted. And the report of the judge rapporteur is basically like a mini version of the judgment. It sets out the facts of the case, the arguments of the parties, and what the judge rapporteur thinks the judgment should be, or how the judge rapporteur thinks the judgment should go, which is drafted by the referendar, remember. So these green bits are sort of the only actual bits that the referendar, or that are going to be new, written in the judgment. So already before a case is even, so these redrafted questions, by the way, are sent out to all other member states in case they want to intervene. And so even before a case is sort of started, or a judgment has even begun to be deliberated upon, there's a sort of a hidden translation going on that has an impact on how these judgments look in the end. Now the referendar who are working, they work in French, they all work in French, and they are of course very highly competent in French, you would have to be, but the majority of them are not French mother tongue. And this has an impact on how they work. First, while they draft in French, the thinking process behind the drafting for many referendaires is done in their own mother tongue. And consequently, the legal reasoning applied by those referendaires is based on the legal reasoning embedded in their national legal systems or the legal systems of the states in which they were educated. This legal reasoning and its associated concepts are developed through intellectual reasoning processes in a particular cultural context, and then expressed in a legal language that develops along with a particular legal order. Language plays a very significant role in Friedman's concept of law as a system or a product of social forces. In his view of legal culture, the law itself is a conduit of those same forces and can be expressed only through the language which is bound to a particular legal order. It's almost impossible to separate a particular type of legal reasoning from the legal language in which that reasoning is embedded. So a legal scholar is therefore reined in by his or her own legal language. In addition to that, most of the referendaires we've interviewed over the course of the past 5 years report working from glossaries they have constructed themselves on what they call the basis of the settled case law of the court. And they say things like, I know what I want to say, and I get my glossary out, and I find something that is kind of the gist of what I want to say, and that starts me off in my reasoning. And so I think you can see there's a very clear impact of that language has on shaping the case law. That also goes to the development of this notion of de facto precedent that we're looking at in part of the project. There's also things like there's internal pressure to consistently use the same phrases to speed up the translation process, so computers can pick it out. If you want to say something and it's previously been kind of said in a case before that's been already written, then just cut and paste that. Then it's all translated already. It speeds up the whole process, and things get processed very much more quickly. And there's also an element where a referendaire who can be relatively young in their careers. When I worked at the court, for example, I was only in my early 20s, and there was no way I was going to turn around and say, I don't think the court's way of saying that in the Costa against NL case was very good. I'm going to change it. So there's an element of that as well, and all of this has an impact. And I think that the impact of this sort of hidden translation on the linguistic development of the case law is quite clear. On the one hand, although referendaires are working in French and applying EU law, they're reined in by their own legal language and the legal reasoning embedded in it. And on the other hand, however, it's clear that the legal reasoning they employ at the court is not fully transposed from their respective national legal systems, because they are working within this particular language and culture, institutional culture. The next stage in the process, The next stage in the process further embeds the institutional language of the court and adds another layer of hidden translation and linguistic compromise to the case law. The judgment, this report, this sort of draft judgment, is produced, and it's taken into the relevant chamber's deliberations, which are secret. So the judge rapporteur takes the draft judgment into the deliberations, and we don't know what happens in those deliberations. They are ostensibly conducted in French. Anybody you speak to will tell you they are conducted in French. I've been in the deliberations room, not during deliberations, and English language translations of all of the documents are also provided. So we don't know whether they're consistently speaking French or working in French within those deliberations. None of the members go into those deliberations blind, of course. They have these notes de délibéré, they have these notes are circulated before the meeting. And this allows members to have the opportunity to work on their own submissions, or where relevant, if their French perhaps isn't very strong, and they're heavily dependent on their referendaire in terms of language. They can then produce written notes that they can read out in the deliberations and rely on. Nobody other than the judges involved in the deliberations in a case will know where the compromises might lie in an individual judgment. The final text that comes out, so the text that goes in, you can see here, we've got this green bit, and it will be changed by the judges. However, if you can imagine this being sent to the translation division without colour coding, the lawyer linguists who are doing the translation don't know where those compromises lie in the text. They don't know if the judges spend 3 hours, 3 days, or 3 weeks arguing about how a certain concept or phrase should be written in French, and yet they have to produce the authentic version of the judgment, which isn't the French version that comes out. Obviously, in French language cases, it is. So they are the various elements of compromise, elements of linguistic cultural compromise that I see in the producing of the judgment. There is, of course, then moving on to the element, the more visible element of translation, the linguistic cultural compromise in sending that case law out to the wider EU. I won't go into how the sort of translation process at the court. They use a pivot translation process, so it's a mix where they can. They do direct translation, but there are 5 pivot languages of the court, and each of those languages is paired up with another language. So the English, French, Spanish, German, and Italian are pivot languages. So English, for example, is paired with Czech and Lithuanian, I believe. So any documents in Czech or Lithuanian will first be translated into English and then to the other languages. So that's there's a lot to be said about it. A lot of things to say about that, but we won't talk about that today. In terms of this idea of linguistic cultural compromise, the first area of compromise that the lawyer linguists at the court engage in is general to all types of translation, and it's the extent to which equivalence can be assured through translation. This idea of translation theory, really, in spite of a very long history of dating back to Cicero, I guess. It's still developing today. It's still considered to be developing today, the translation theory. And one of the central concepts is this notion of equivalence, how to render a source text equivalently in the target text. And that's inextricably bound with notions of translatability. Now, very few translation theorists claim that all meanings of a concept in a language are always translatable. Now, most people will agree that the very nature of language means that any concept occurring in one language can be rendered in some form in another language. The general consensus in translation studies, therefore, is that most concepts and texts can be translated within certain limits. And we have to remember that languages are multi-layered expressions of human cultures, and as Keenan points out, they're efficient only insofar as they're imprecise. It follows, therefore, that any successful or efficient translation must be accordingly imprecise. The emphasis in general translation theory today has shifted from interlingual transfer, where the focus was on obtaining a maximum degree of linguistic equivalence, so reproducing a very literal surface meaning of the original text, to cultural transfer, where the focus is on translation as a process of negotiation between texts and between cultures. And so any consideration of translation will obviously involve a consideration of the relationship between language and culture. And I'm aware of time, so I won't go into I'll let you read them, these quotes yourselves. But translation between languages involves not only transfer of meaning at a linguistic level, but also the transfer of extra-linguistic meaning tied up with a particular concept in a particular culture or human system. And within translation studies, there does appear to be an implicit understanding and acceptance of both the limits of language and translation, and of the fact that there's ordinarily no full equivalence through translation, only degrees of equivalence, and that translation is an approximation of sorts, all translation. In terms of legal translation, however, there is a tendency for legal texts to be considered as special purpose texts for the purposes of translation, and so they're often placed in the same bracket as scientific or technical texts. And special purpose texts are usually informative texts written in a special language, the terminology and syntax of which will be specific to a particular field or subject area. And scholars in the field of special purpose texts or special purpose languages maintain that since the content of those texts is independent of cultural context and that there's a common system of reference, perfect communication is possible through translation. So we're talking about scientific fields, hard sciences really. And it's easy in one way to see why many people include legal texts under that definition of special purpose texts, since they are written in a special legal language, usually reserved for communication between lawyers or specialists. So again, going back to what Jan was talking about earlier today. But unlike the natural sciences, unlike the hard sciences, legal texts absolutely do not have a single agreed meaning independent of local context. And as Sartvik points out, bound to a particular legal system, each language of law is a product of a specific history and culture. So unlike technical languages of engineering or mathematics or medicine, there's no universal legal language or even universal legal terminology. Each legal system in the world today has a very specific vocabulary, a unique legal language used to express concepts, and each language has its own techniques for expressing and interpreting rules and is linked to a view of the social order within the relevant state or organisation. So since the meaning of legal text is determined primarily by legal context, they shouldn't, I believe, be placed on the same footing as other special purpose texts for which a common terminology exists. Didier's definition of translation here about transferring a legal message from one language into another legal system is the generally accepted definition of legal translation. So translating concepts from one legal order into another. And so, as I previously mentioned, legal translation is about incongruency of legal systems. Legal texts, so while legal texts shouldn't be treated in the same way as special purpose texts, I would go further and say that translated texts which have the force of law also have to be considered distinct from other types of texts, because their translation is concerned with legal transfer as opposed to cultural transfer. And legal transfer is concerned with the effect, producing the same effects in the target legal system as it does in the source legal system. And in practice, achieving a target text that expresses the precise meaning and achieves the same legal effects intended by the author of the source text is extremely difficult, because it's dependent on the rules and methods of interpretation applied by the receiver of the target text. The translation of judgments at the Court of Justice have force of law where those translations are declared authentic versions of the judgments. The translators responsible for producing those translations have to therefore strive to achieve that almost impossible task. And the effort to do that highlights the second type of linguistic cultural compromise in the translation process at the court. And this is one that goes to a dual professional identity. Those who do the translations at the court are lawyer linguists. And the title lawyer linguist brings to mind two very different professions, lawyers and translators. There's a vast literature on the subject of lawyers, who they are, what they do, what their role definitions are, and the concept of the legal profession. And those role definitions and the concepts of legal profession might differ between states and legal orders. There are nonetheless norms that they have in common, and those norms relate to the need to remain faithful to the law, or the effort to avoid an uncertain rule of law. And they're reference for lawyers' behaviour. In order for the law to function, it has to be considered definite and precise and deliberate. And so lawyers' role definitions are usually grounded in sort of specific positive concepts. And there's a similar literature that exists on the profession of translators. And that literature focuses on concepts such as the translation as an author, or the power of the translator, the limitations or constraints of the translator. And underlying all of those role perceptions is the implicit and in many cases explicit acknowledgement of the indeterminate nature of translation. Translation is a process of negotiation. Translators are considered mediators. Their work is a compromise. So if legal translation is concerned with the effect of the translated texts, while legal translation might involve approximation in a linguistic or cultural level, it is possible in theory for a legal translator to produce a target text that expresses the meaning and achieves the legal effects intended by the author of the source text. In practice, however, that's incredibly difficult to achieve and as I said, largely dependent on the rules of those who are going to be receiving the text. And the contradictions between these two professions are significant, I think. On the one hand, lawyers are defined relative to this definite, determinate concept of the law, and on the other hand, translators' role definitions are based on the acceptance of the indeterminate nature of language and translation. So the two professions and their respective norms appear to be incompatible, and yet in the context of lawyer linguists at the Court of Justice, they're brought together. And so what we've seen in the project is that while they're dealing with the classical problems of translation on a daily basis, they're also trying to balance this dual professional identity, that of lawyer and linguist. And these quotes are indicative of across the board. There wasn't a single lawyer linguist interviewed who didn't talk about this tightrope act, this balancing the two role perceptions. And so the many cultural compromises involved in the drafting process and the multicultural reasoning employed in producing the case law are reflected in a French that's unique to the Court of Justice, a court French, a new legal French that demonstrates elements of hybridization reflecting the linguistic cultural compromises through which it has been created. Part of what we did in the project was look for that language. This goes back to my sort of obsession with methodology. I don't feel it's good enough to just say I've interviewed people and they tell me there's a court French and I used to work there and I know there's a court French. I don't think that's good enough. I want to triangulate that in another way, and so I can feel that I'm very grounded in what I'm saying. And so we did a corpus linguistic analysis of it, and this hasn't come out very well, but we looked at repetition degrees and formulaicity, and we were basically able to show that the Court of Justice, that there was a court French. We then looked at the other languages, so the translations of what is produced in the court in French, and what we should have found is that they were all equally formulaic, equally hybrid, and equally repetitive, but we didn't. So there appears to be not only a court French in which the court works and which all the judgments are drafted, but the other 23 languages don't reflect that same a court French. I don't know that it's problem necessarily, but it was an interesting thing to see. An oft-repeated refrain that we've come across through the empirical work for the project is that the focus of the court is on French. People talk about the French bubble, and that the court is in fact a monolingual institution that just has a multilingual output, and the multilingual output is just tacked on to the end of the process. People said the only version of the judgment that the court cares about is the French version. Interestingly, what we found is that the data on this is contradictory. So the interview data indicates that within the court, the French version is the most important version. French is in a very real sense the working language of the court, and in theory no progress can be made on a case until the French version of all the relevant documents are in front of the relevant referendaire. The interview data also shows, however, that due to pressures of workload, work is often begun on a case before the referendaire receives the French translations. If it's a Spanish case and the referendaire can speak Spanish, they will go and look at the original pleadings and they'll start working in French on the basis of the Spanish originals. So they don't always wait for the French. And that, of course, all feeds into this blended culture and linguistic cultural compromise in producing the case law. In addition to this, the empirical analysis of the case law itself shows us that where there are discrepancies in language versions of previous judgments, I'm talking about judgments, not legislation here, so where there are discrepancies in language versions of previous judgments, the court doesn't simply just look to the French, which, if this notion of the French bubble and French being the most important version was true, you would assume that's what the court would do, but they don't. And it's almost evenly split. Their approach that the court takes is almost evenly split between either carrying out a linguistic comparison of different language versions and coming down in favour of the most common translation, or reverting to this sort of Silphate argumentation of there being one EU law, one EU rule, one EU assertion, which is simply expressed in 24 different linguistic forms, and those different linguistic forms might lend themselves linguistically to different interpretations, but nonetheless they have the same legal meaning. This teleological interpretation that Isolde was talking about when you looked at the legislation. And when I interviewed judges about this, many of them said, well, we know what the answer will be. If a linguistic comparison gives us that answer, we can stop there. If it doesn't, we can go and use our teleological interpretation. And so when you crunch the numbers, it comes out almost equal there. So it appears, therefore, that linguistic cultural compromises that go into building and the reasoning of the court actually create this unique teleological interpretation process or interpretative method. The people involved in producing the case law might believe that French is the only version of the judgment that matters throughout the entire production process, but the reality is probably two layers. I would say, firstly, at the drafting stage, the focus is certainly on the French version. But it's a French that reflects the hybrid institutional culture and these linguistic cultural compromises. It's a French unique to the court. And then I'd say, secondly, those linguistic cultural compromises are in fact acknowledged, albeit not explicitly, in situations where interpretation is necessary. And the court carries out this teleological interpretation. Bengochea submits that the court's reasoning is monolingual but multicultural and unique to an autonomous supranational EU legal culture. And the data that we have looked at so far in the project supports that thesis. But I would go further. And I'd say that the multicultural element of that monolingual reasoning consists not only of a blend of reasoning based in diverse legal orders, but also of layers of translation, both overt and hidden, and linguistic cultural compromises without which the case law simply couldn't be produced. At the beginning of the talk, I posed the question, why should we care about any of this at all? Well, I mean, I think acknowledging the impact of language on translation is important in and of itself, but I can also identify 3 specific reasons that I think is important. It lets us, first of all, develop a more holistic understanding of EU law, a fuller understanding of EU law. Secondly, it highlights that there is more to the creation or the development of the court's jurisprudence than what's necessarily intended by the judges. Now, that's the same in any court. There's nothing unique about the Court of Justice in that regard. But translation introduces another element, whereby that intention might be distorted as the jurisprudence is then delivered out and interpreted within the wider EU. And finally, I think it supports the more pluralistic views of the development of EU law. So traditional EU constitutional narrative centred on harmonisation and uniformity for the sole purpose of serving the European integrationist cause, and differences and diversity in integration process were perceived as obstacles, originally to free trade, I guess, and then to integration. And that constitutional vision became inadequate increasingly, and it was gradually reworked, and recent EU constitutional narratives centre around this notion of constitutional pluralism. Now, it has to be fully defined yet, it's still being elaborated, but all of the concepts within that idea of constitutional pluralism in the EU constitutional narrative share a fundamental quality insofar as they present a theoretical take on EU integration based on analysis of the development of a European rule of law, drawing on theories of law and judicial reasoning. I think that by clarifying the ways in which language plays a key role in determining judicial outcomes, it provides us an opportunity to rethink how these differing versions of constitutional pluralism might fit together. And so for me, these are the whys, the kind of the so what element to it. And I've probably gone on far longer than I should have, but that brings me to the end.